This short guidance video is one of a series produced by JISC Legal in supporting staff who are directly involved with business and community engagement or BCE activities within their institution. JISC Legal are one of several services that are part of the JISC BCE programme. We will begin with a short overview of the legal implications for data sharing and research. This will be followed by an interview with John Reid, an associate of McRoberts, who will explain for you in more detail the application of the Data Protection Act, the research exemption, the role of the data controller, and implications of sharing personal data with third parties. We will then conclude with a brief look at freedom of information legislation and data sharing agreements. So within BCE, when might data sharing for research occur? There are three situations where this may apply. The first is where the institution is sending personal data to another institution or partner organisation, or it might be where the institution is receiving that personal data from the other party, or it might be where a third party requests that data and it's being held by either or both partners. It's important for an institution to establish in what capacity they are acting. Where they are controlling data and sharing it with another party for the same purpose, then they will be joint data controllers and they will be jointly liable under the Data Protection Act for any breach that arises. Where the institution and the partner are sharing data for different purposes, then they will be data controllers in common, and this means that each will be individually liable for that processing. Institutions should also consider whether any other law may apply when they are proposing to share data, the law of confidence, for example. John Reid, an associate from McRoberts Solicitors, will now describe for us in more detail what institutions need to be aware of when sharing data for research purposes. Why is data protection relevant to research projects?
Data protection is a very important issue. If you are processing personal data, then it's very likely that you will have to comply with the Data Protection Act, in particular the data protection principles. Now, these principles could cause a bit of a difficulty if you wish to use personal data for research projects. So for instance, if personal data has not been collected for the purposes of research, well, can you actually use that for your research project? If you have personal data, well, can you share that with other researchers involved in other projects? So these are just some of the issues which can arise. One of the other very important issues is to identify at the outset the identity of the data controller. The Act imposes obligations on data controllers. Now, the data controller is the party who determines what data is processed and what that data is processed for. So in the context of a research project, it could be the institution, it could be a commercial partner, it could be a third-party funder, or it could be some other party, or indeed it could be any of the foregoing. So it's very important at the outset to identify who is the data controller, who has legal responsibility for this data.
Can the data controller share with third parties?
Well, it really depends. In some circumstances, the data controller may wish to engage a third party to carry out some processing on its behalf, and generally that's fine, but the data controller must put in place a data processing agreement with that third party. Now, the purpose of the data processing agreement is to impose obligations on the data processor, very generally to take care of the data and to only process it for the purposes for which it is specifically authorised. If a data controller wishes to share personal data with a third party other than a processor, then certain questions have to be asked. So first of all, have the data protection principles been complied with? Now, if they have, it's generally fine to share that data with third parties. If they have not, you then have to ask if any exemptions apply in the circumstances. Now, if an exemption applies, it's generally fine to share that data, provided you stay within the confines of the exemption. If an exemption is not available, then it's reasonably safe to assume that you should not be sharing that data with a third party. Now, where a data controller does wish to share data with a third party, they should have a code of practice in place, which basically describes the manner in which and the purposes for which data will be shared. It basically sets out the underlying principles of any data sharing arrangement. In addition to this general arrangement, I would always advise clients that if they're sharing data with a third party, to have a specific data sharing agreement in place so that it's clear within the four corners of the agreement just what that party can do with the data, what they can't do with the data, and any security arrangements which will apply to maintaining the security and integrity of that data.
You mentioned exemptions. Can you tell us about the research exemption and how this will benefit researchers?
The Act makes specific provision for a research exemption. Now, research in the context of the Data Protection Act is defined very widely indeed. It covers the full spectrum from fully academic research to a fully commercial research project, so it is very wide indeed. The exemption gives researchers certain leeway provided that two key conditions are met, and these are referred to as the safeguard conditions. First of all, the data must not be used to support measures or decisions with respect to particular individuals. And secondly, the data must not be processed in such a way as to cause substantial damage or distress to any data subject. But provided that these conditions are met, you can process that data for research purposes, even if it was originally acquired for another purpose. And you can also retain that data indefinitely. Now, one further point in terms of data sharing is that if you fall within the terms of the exemption and you meet the conditions, then you can share that data with other third parties, provided that it is for research purposes.
What about anonymisation? Would it be better for institutions to use anonymised data?
I think anonymisation is a very important issue, and generally if I'm advising clients, I will always say to them at the outset, do you actually have to have this information in the form of personal data? Or can you strip out the personal identifiers, just leaving you with raw information? The benefit of the latter approach is that raw information with no personal identifiers does not constitute personal data, and therefore it falls out with the scope of the Act. So from a risk management point of view, I think that anonymisation is a very practical solution which can give you a lot more scope to actually use that data, so indeed that information for your research purposes.
Institutions should also be aware that as a public body, a college or university will be subject to freedom of information legislation. This means that an institution may have to reveal information about their BCE activities. This includes information about a private company, unless an exemption applies. This is worth bearing in mind, as this might be a source of concern for such partners. An understanding of the exemptions and when they may apply will therefore be required. Such exemptions may include the absolute exemption that refers to personal information, or it might be a qualified exemption that applies, which means that this is subject to the public interest test. Certain qualified exemptions include information that's intended for future publication, confidential information, and information which, when disclosed, may prove prejudicial to the commercial interests of either partner or both. Your own institution's FOI policy will determine how this works in practice. And remember, think carefully about what information you hold. For example, is it really that necessary to retain it? If you don't hold the information, you don't have to disclose it. Further information on FOI can be accessed from our own JISC Legal website and also through the Office of the Information Commissioner. So in most cases, data protection law does not expressly prohibit the sharing of research data between parties, but it does require that appropriate contracts are in place. This might be a joint data controllers contract or agreement, it might be a data sharing protocol, or it might even involve a code of practice. It's also important to comply with all other relevant aspects of the Data Protection Act. Contracts or agreements at the outset should address what type of data is being shared, make the purpose clear, consider any sharing of data to third parties, and also address issues relating to retention of data after conclusion of the contract, and also provisions should be in place for deletion of that data. And as we heard from John earlier, anonymisation of research data should be encouraged wherever possible. This will prevent any unnecessary breach of the Data Protection Act. Equally, an institution might consider asking the partner organisation to anonymise any data that's being sent to it. JISC Legal have produced a document dealing specifically with data sharing, and we would recommend that you have a look at that. And as a member of staff in further or higher education, you can always contact us for further information. You can do that by giving us a call through our help desk or sending us an email.